All right. So you see in your seats, there's a blue binder and some materials in there. Should be a writing utensil, some paper, form to fill out questions. I'll explain all that stuff as we go. The law requires that I would both.
Before a single witness testifies, before a single piece of evidence is shown, the stakes are already crystal clear. A stolen truck, a late-night sighting, no direct evidence, and a case built almost entirely on circumstantial clues. The state of Michigan says the puzzle only fits one way, guilty on all counts. But the defense says the prosecution is forcing pieces together that simply don't belong. So here's the real question. When there's no eyewitness identification and no direct proof, is suspicion enough to convict? Let's step inside this courtroom and break it down.
Give you a written copy of those instructions and also read them to you. Sometimes folks find it helpful for themselves to follow along. If you're one of those folks, that's fine. Other times folks find that distracting, and that's fine. I'll read you what's in it. So it's totally your choice. But first off, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. So I will now ask you to stand and swear to perform your duty to try the case justly and reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. So at this point, I'm going to ask you to stand and raise your right hand, and the clerk will administer to you.
Each of you do solemnly swear that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only upon the evidence introduced and in accordance with instruction of the court. So help you God.
Okay, thank you. Please be seated. As I said, you have a written copy of the instructions I'm about to read to you. You may refer to them during the trial. And since no one can predict the course of a trial, these instructions may change at its end. And at the close of the trial, I'll provide you with a copy of my final instructions for your use during deliberations. I'll now explain some of the legal principles you'll need to know and the procedure we'll follow in this case. In count one, the defendant is charged with the crime of breaking and entering. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant broke into a building. It doesn't matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, or taking off a screen are all examples of enough force to count as a break-in. Entering a building through an already open window or door without using any force does not count as a break-in. Second, that the defendant entered the building. It doesn't matter whether the defendant got his entire body inside. If the defendant put any part of his body into the building after the break-in, that is enough to count as an entry. Third, that when the defendant broke and entered the building, he intended to commit the crime of larceny, which is an unlawful taking or carrying away of another person's property without their consent and with the intent to permanently deprive the owner of their property. In count two, the defendant is charged with the crime of larceny. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the property was taken without consent. Third, that there was some movement to the property. It doesn't matter whether the defendant actually kept the property or whether the property was taken off the premises. Fourth, that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. The intent to permanently deprive includes the retention of the property without the purpose to return it within a reasonable time, and includes withholding property or causing it to be withheld from a person permanently or for such a period of time that the person loses a significant part of its value, use, or benefit. Fifth, that the property had a fair market value at the time it was taken of $1,000 or more, but less than $20,000. In count three, the defendant is charged with the crime of unlawfully driving away a motor vehicle. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the vehicle belonged to someone else. Second, that the defendant took possession of the vehicle and drove it away. Third, that these acts were both done without authority and without the owner's permission. Fourth, that the defendant intended to take the vehicle without authority, knowing that he didn't have the authority to take the vehicle and drive it away. It doesn't matter whether the defendant intended to keep the vehicle. Anyone who assists in taking possession of a vehicle or assists in driving or taking away a vehicle, knowing that the vehicle was unlawfully possessed, is also guilty of this crime if the assistance was given with the intention of helping another commit this crime. I'll remind you that a person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements that I just read to you, and the prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. And a reasonable doubt is a fair and honest doubt growing out of the evidence or the lack of evidence. It's not merely an imaginary doubt or a possible doubt, but it's a doubt based on reason and common sense. So a reasonable doubt is just that, a doubt that's reasonable after a careful and considered examination of the facts and circumstances of the case. Now, the trial will follow this procedure. First, the prosecutor will make an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make one after the prosecutor makes his, or he may wait till later. These opening statements are not themselves evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify, may show you exhibits like documents or objects, and the defense lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defense attorney may also offer evidence, but doesn't have to. By law, the defendant doesn't have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them and may also call witnesses to contradict the testimony of defense witnesses. And after all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not themselves any evidence. They are only meant to help you understand the evidence and how each side views the case. You must base your verdict only on the evidence. Now, my responsibilities as the judge in the case are to make sure that the trial is run fairly and efficiently, to make decisions about the evidence, and to instruct you about the law that applies to the case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinion about the facts of the case. As jurors, you will decide, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe of what each of the witnesses said. And what you decide about any fact in this case is final. Therefore, part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You don't have to accept or reject everything a witness says. You're free to believe all, none, or part of anyone's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's disability, race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe what a witness says, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long were they watching or listening? Was anything else going on that might have distracted them? Does the witness seem to have a good memory? How does the witness look and act while testifying? Do they seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Do they have any bias or prejudice or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, do they have any special reason to tell the truth or any special reason to lie? And all in all, how reasonable does the witness's testimony seem when you consider all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. Now, the questions that the lawyers ask the witnesses are not themselves evidence. Only the answers are the evidence. So you shouldn't think that something is true just because one of the lawyers asks a question that assumes or suggests that it is. During the trial, I may ask some questions of the witnesses. These are not meant to reflect any opinion I might have about the evidence. If I were to ask any questions, my only reason would be to ask about things that have not been fully explored. And during the trial, you may think of an important question that would help you understand the facts of this case. You are allowed to ask such questions. Let me explain to you how that process will work. We'll have the witness testify. Both the lawyers will finish their questions. If I have any questions, we'll finish all of those. And then I try to ask the jury, do any of you have questions for the witness? If you do, raise your hand. Don't ask the question. That's why we've given you the form and writing utensils. So write down the question that you have. Fold it in half so nobody else sees your question. And the bailiff will take it from you and bring it up to me. I'll review it. I'll ask the lawyers up to the bench, give them a chance to look at it, and then I'll decide whether I'm going to ask the witness your question or not. If I have forgotten to invite you to do that, that's okay. Sometimes I forget. But if at the end of the lawyer's questions, if you have a question, just raise your hand. If I've forgotten to invite it, that's okay. And we do that process so that I can review the question with the lawyers to see whether under the law the question should be asked or not. So if I don't ask your question, that's because I determined under the law that the question should not be asked. If that happens, please do not speculate about why it wasn't asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what your answer might have been. Also, in considering the evidence, you shouldn't give greater weight to any testimony merely because it was given in response to a question from the jury. Now, during the trial, if you can't hear something that is said or presented, or if you can't see a witness or exhibit, please raise your hand immediately. As I said, you're the judges of the facts of the case, so we need you to see and hear everything clearly. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or by a witness. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinion about the facts of the case. Sometimes the lawyers and I will have discussions out of the hearing, and while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. We'll try to minimize that, but it's during a trial, it frequently happens where we'll have to discuss an objection with more detail, and so we'll send you back to the jury room while we do that, if it's something we can't just take care of momentarily here at the bench. So if you have a Fitbit, you're going to get lots of steps in today back and forth to the jury room. We try to keep that to a minimum, but it seems to be unavoidable in every trial. Now, you must not discuss this case with anyone, including your family or friends, and you must not even discuss it with other jurors until the time comes for you to decide the case. The reason for that is, like the old Paul Harvey, the rest of the story. We don't want, if you start talking about your impressions as the trial's happening, then that can cause you to kind of lock in those impressions. And we don't want that to happen. So this is a surprising sometimes to the jurors' instruction, but during the trial, we don't want you talking to each other about the case at all. Talk about the weather or baseball, your families or whatever, but don't talk about the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. And then, and only then, you should discuss the case among yourselves, but only in the jury room and only when all the other jurors are present. You also must not talk to the defendant, the lawyers, the witnesses, or anyone connected with the case. This means you can't talk to those folks, even if it has nothing to do with the case. So you should be very cautious about speaking to people because you may inadvertently speak to someone connected with the case. This restriction is necessary to avoid even the appearance of any improper conduct on anyone's part. If someone does try to discuss the case with you or in your presence, tell them to stop and explain that you're a juror and you're not allowed to discuss the case. And if they continue, leave, and please report any such incident to the bailiff as soon as you return to court. When the trial is over, of course, these restrictions no longer apply. And when the trial is over, you can talk about the case with anyone you wish if you choose to. There are some additional restrictions I'm about to describe, and these are meant to ensure that the parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, evidence that you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side or the other. So these restrictions start now and they continue until I discharge you from jury service. It's your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider any information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about this case, whether in newspapers, television, radio, internet, or social media. You also must not research any aspect of the case during the trial. This means research using a cell phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cell phones, computers, or other electronic devices. And you must not visit the scene or location of any event in this trial. If it is necessary for you to view or visit the scene, we would take you there as a group together under court supervision. So you must not consider as evidence any personal knowledge you have of any location. And you must not share any information about the case by any means, including cell phones or social media. This means that even if you're not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner whatsoever. Also, during this trial, you may not view or visit anything on this court's or this judge's YouTube channel, whether it pertains directly to this case or not. And if you discover that a juror has violated my instructions, please report that to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, please be careful that it doesn't distract you from paying attention during the testimony. And when you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you do take notes, don't let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. So how we handle this logistically is you can keep those in or with your blue binders. Those blue binders and your notepad should be in one of two places, either with you back in the jury room or in your seat out here in the jury box with any notes face down. When we break for lunch or this evening, you may not take the notebooks or any of your notes with you. Just leave them here, either in your seats here or the jury room. And at the end of the trial, my staff will collect those face down and destroy them, and nobody reads any of those things. Now you can see that we have chosen a jury of 14. After you have heard all the evidence in my instructions, we will draw lots to decide which two of you will be dismissed to form a jury of 12. So the reason we do this is that sometimes there are situations that occur in our lives or our families. And if something like that happens, please bring it to the bailiff's attention and then we can address it with you. So I always choose a couple alternates so that if something like that happens, when we get to the finish line, we want to be sure that we have 12 people left. If we have more than 12, we will randomly excuse the extras as alternates. Any possible penalty should not influence your decision. If you were to find the defendant guilty, it would be the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and after all the evidence has been presented, you'll hear the lawyer's closing arguments, and after that, I'll give you more instructions, because this was really fun and entertaining. So we'll do it all over again, and I'll give you a lot more instructions. You should consider all my instructions together as a connected series, and they are together the law that you must apply in the case. After my final instructions, you'll go to the jury room to decide on your verdict, and a verdict must be unanimous. This means that every juror must agree upon it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make any decision about anything in the case until you go to the jury room to decide the case. So you must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of those, but we don't express them. And we may not even be fully aware of some of our other biases. Therefore, take the time that you need to test what might be an automatic or instinctive judgment and reflect carefully about the evidence. I caution you to avoid reaching conclusions that may even be unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of your fellow jurors who may have different backgrounds or perspectives than you do. Now I'll conclude my preliminary instructions to you. And at this time, Mr. Juliet will receive your opening statement.
Thank you. Good morning, ladies and gentlemen. Again, my name is Anthony Juliet. I represent the people of the state of Michigan in this case. This case is about pieces of a puzzle that only fit one way. Every crime leaves footprints somewhere. Once we get this going, I'm going to start off with the crimes that the defendants accused. Portions of that video that show a person in a camouflage jacket with white lettering on their shirt and a ball cap, leaving the bank parking lot and going into the defendant's, or excuse me, Miss Harmer's yard, and then going into the garage. Again, paying close attention to that Mackinac Bridge video. That person crossing that bridge was wearing a hat with white lettering and a black shirt. So this is all about connecting the dots. Again, there is no direct evidence. I'm going to be honest with you right now. But after you hear all of the circumstantial evidence, the vehicle, the bridge video, the bank video, the forms of identification, this really is a case that leads in only one direction. That's guilty of all counts, and that's the verdict that I'm going to ask you to return. Thank you.
Thank you, Mr. Nightingale. Do you wish to give a opening statement at this time?
I do, Your Honor. Thank you.
Okay, ahead and proceed.
Morning, everybody. So now the fun kind of starts, I guess. Yeah, I guess today, we're going to ask you to look at all the evidence that you see, right? We're going to ask you to examine the evidence that you also don't see, and that's not going to make a lot of sense to you right now until you get farther into the trial. But, I'm glad that Mr. Juliet and I are on the same page, that there is absolutely no direct evidence here that connects Mr. Middleton to this crime. In fact, it's all circumstantial. And so what you guys are going to have to do is examine that evidence and see if you agree with Mr. Juliet. It is our contention, our position, that yes, of course, puzzles are supposed to only fit one way. But what the prosecutor is doing here is trying to take the puzzle pieces and jam them into the puzzle to try to make them fit for you. That's not how puzzles work, and that's not how they function, and not how the criminal justice system is supposed to function. And so what we're asking you to do today is to pay attention, use your common sense, Think about the things that we talked about in jury selection. What is a coincidence and what is circumstantial evidence? And when you reconcile all these things together, there's only one thing that you guys are all going to think together, and that's that Mr. Juliet did not meet his burden to prove beyond a reasonable doubt every element of each of the offenses. Every single element he must prove to you beyond a reasonable doubt, and he is going to fail in that regard, and you guys will all return a verdict of not guilty on all counts. Thank you.
Thank you. Mr. Juliet, your first witness.
People call Morgan Harmer. Check outside.
Ms. Harmer, if you please come on up to the witness stand here, and as you arrive, please remain standing and raise your right hand for me. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. Okay, you can be seated. Go ahead, Mr. Juliet.
Thank you. Good morning. Can you state your full name and spell your last name for the record, please?
Yes, Morgan Marie Harmer. Harmer is Harmer.
Okay, thank you. Where do you live?
In Wolverine, Michigan.
Okay, is that in Sheboygan County, Michigan?
Yes,
How long have you lived there?
for about 10 years.
Okay. And who all lives there?
My husband Lance Harmer, my daughter Nora Harmer, and my son Bennett Harmer.
Okay, and they've all lived there the same amount of time? Were you living there on or about May 6th of 2024?
Yes,
And was everybody there with you that day?
yes.
Now, did you have some contact with law enforcement early that morning?
Yes, I did.
Okay, about what time?
About 3:45 in the morning.
Okay, what was the reason?
Our vehicle was being stolen out of our driveway.
Okay, and what kind of vehicle is that?
It was a Ford F-150.
Okay, is that your vehicle or your husband's
That
vehicle?
was my husband's vehicle.
Okay, you had your own vehicle there?
Yes.
Okay, so sort of describe what happened, how you came to see somebody steal your husband's vehicle.
Yeah, so my daughter actually woke me up about 3:45, said she heard some loud noises outside. And I went to go check it out. I saw someone messing around, pounding on a vehicle down at the credit union, which is near our home. Once that happened, I didn't think anything of it at the time. When I turned to look into my dining room, I realized the lights on my husband's truck were on. And I also saw that there was a person in the vehicle. At that point, I ran to grab my husband and I called 911 at the same time.
So I want to go back to this vehicle you saw at the bank. Do you remember what kind of vehicle it was?
I don't. I know it was a car and it was, I believe it was silver.
Okay. Did you see anybody near the car?
Yes, there was somebody messing around, it looked like with the front of the vehicle.
Were you able to make any visual identifiers of that person?
I mean, as far as skinnier, taller, nothing distinct.
Okay. Color of clothing?
Black.
Black. Okay, and then you said that there was somebody in your husband's vehicle.
Yes,
Okay, were you able to make any visual identification of that person?
as far as what the person was wearing, it was a camo jacket with like longer, like shaggier hair. But that's about it.
Okay. Now, so what did you do? So you called 911.
Mhm.
Did anything happen after that?
Yeah, so once I got 911 on the phone and my husband helped, he ran to the kitchen with me. At that point, the person that was at the vehicle at the bank ran up and jumped into the truck, and at that point they took off.
So again, I just want to kind of separate these two people. Who did you see get into the driver's side of your husband's truck and drive it away?
The gentleman in the camo.
Okay. And did the other individual get in as well?
Yes.
Back to the silver vehicle at the credit union. Is it common for vehicles to go in and out of that parking lot?
Sometimes it's the only area that's lit up. So we've seen people stop and check something out with their car and then take off.
Okay. Had you been at your house all day that day?
Other than work, yes.
Okay. What time did you get home?
Probably about 5:30 p.m.
Okay. Was that silver vehicle there all day?
No,
Okay. When do you first remember seeing it there?
just that morning, about
Okay,
3:45.
that morning? It wasn't there when you went to sleep or anything like that? Okay. So it's fair to say that you can't identify who stole the vehicle or who was going through your truck or
No.
anything like that? Now, after the police had arrived, did they give you an opportunity to check to see if anything was missing from the vehicles or your property or anything like that?
Yes, they had me check my car. Of course, everything was thrown around as far as the glove compartment, so it's obvious that they were in the vehicle as well. The garage itself, apparently they were in. There was a hammer that was left outside that was not ours. But nothing as far as the house.
Okay. No, you said a garage.
Mhm.
Can you describe the layout of your property?
Yes, so the garage is placed right next to the house, which is the closest to the bank. And the door to enter the garage is on the left-hand side with the garage door, the large garage door on the right-hand side.
Okay. And is it your regular practice or routine to close your garage door at night?
Yes,
Do you recall if it was closed?
it was not.
Okay, it was not closed that night?
No, it was closed. It was open though, as of after that.
Okay, so you went and you saw that it was open, but it was
Yes.
closed when you went to bed that night?
Yes.
Did, did you ever get the F-150 back?
No.
Did you file an insurance claim?
Yes,
What, did they pay it out?
yes.
How much was it?
$9,100.
Okay, and was that just for the truck or?
There were brand new car seats in the truck as well,
Okay.
that were paid out as well.
Okay,
And yes,
Your Honor, can I approach the witness?
Yes.
Show you this document. Without getting into the contents, can you just tell me what it is?
yes, that is the settlement summary from the insurance claim.
Okay. And that's for the truck that was never returned?
Yes,
Your Honor, I would move for admission of people's proposed exhibit one, under MRA 8036, business records exception, and self-authenticating under MRA 9211.
Any objection?
No position.
Exhibit 1 is admitted.
And permission to publish.
Yes. So then if you just want to review that and pass it along and then to the back row and then back to.
So just finishing up here, did you see anybody go into your garage?
No.
Okay. Is that because it's behind the house and it would be tough to see out
Yes.
from that angle? Okay. Thank you. I have no further questions, Your Honor.
Cross-examine?
Good morning. So Ms. Farmer, I kind of want to go back to your testimony when you talked about when you woke up.
Mhm.
Okay. Your daughter woke you up?
Mhm.
And were you fast asleep when she woke you?
Yeah.
Okay. And you mentioned that you saw out your window a car at the credit union.
yes,
And you mentioned that you saw someone messing around with that car.
yes.
Do you have any idea what they were doing?
It looked like they were working on it. And I believe the hood was up.
But you don't have really any idea what they may have been doing.
No.
it's possible then they could have been breaking into that car.
Yeah.
And you don't know when that car showed up.
No,
It wasn't there when you went to bed.
no,
And it just appeared at 3:45 or so when you woke up. 3:45 a.m. in May, obviously it's dark outside,
Mhm.
correct?
yes.
Are there lights around your home?
The only light that was actually on was the light that shines behind the credit union. And that shows our entire house.
And you mentioned that it's common for people to maybe pull into that place because it's well lit.
Yes,
They can check their cars or something.
yes.
So when you observed the person by your husband's truck, you say that you noticed they were in a camo jacket.
Yes,
How did you notice a camo jacket?
I could see from the light shining from the bank. Like I said, we can see everything there.
You also mentioned that your husband's car and your car sit side by side.
Yes,
And so this person would have been in between two vehicles.
yes,
A truck and a car.
yes,
And at an angle, you're looking out
yes,
and it's dark, but you
Yeah.
can clearly see a camo jacket.
it looked like a camo jacket, yes.
But you can't see a face.
No.
And you didn't have any kind of descriptive features of the person.
No.
Just the clothing.
Well, other than it looked like they had a little bit longer shaggy hair.
Okay. No color of hair, couldn't tell the color of the hair. Well, you mentioned that it's a regular practice that you close your garage door at nighttime, right? Most people have routines in their house and they do things at certain times, shut all the lights off before they go to bed.
Yes.
Would you agree that, you can do those things 99% of the time, but sometimes you forget?
Yeah.
And it's your testimony today that usually that door is shut, but you don't know for sure that it was shut that night.
Yes,
You aren't 100% certain that that door was closed.
Right.
Okay. You also mentioned that there was a hammer left behind
yes.
and that wasn't any of your property.
No, it was not.
You don't know where that came from?
Yes.
Do you know, Ms. Harmer, where that hammer was found? Was it outside?
I believe it was. I don't remember if it was outside or just inside the door. I believe it was outside.
Okay.
It's been quite some time since then, so.
I don't have anything further here. Thank you.
Interview direct?
Just very briefly. Ma'am, approximately how long was this going on? From when you woke up to when the vehicle was driven away?
I would say 15, 20 minutes.
Okay. And when you were watching this going on, did the two individuals appear to have anything on them, like bags or anything like that?
Yes, the person running from the vehicle at the bank did have a trash bag.
Okay, and do you remember what color clothes he was wearing?
I just saw black
You just saw black?
clothing.
Okay, and just any
Black trash
sort of bag? Okay. Did you see him take anything out of the car?
No,
No?
other
Okay.
than the bag.
Okay, thank you.
Mr. Juliet, would you kindly retrieve the exhibits and hand it to me? Sir? Okay, thank you. Do any members of the jury have questions for this witness? Okay. Counselor Prince, please. Okay, Ms. Harmer, what time is it that you went to bed?
I don't remember.
Do you have any approximate window of
Maybe
time?
10 to 11,
What's
yeah,
that?
around 10 to 11
10 or
p.m. is
11.
normal.
Any follow-up questions as a result of the juror question?
Just to be clear, you did not see the silver vehicle when you went to bed?
No.
Okay, thank you.
Any follow-up questions? Any additional questions from the juror? Okay, seeing none, thank you, Ms. Harmer. Step down. May she be excused from subpoena?
Yes, please.
All right, it being 11:56, time for lunch break, or you have one witness you could do?
Can we approach?
Yes. Have one more witness. It should only take about 3 or 4 hours, and then we'll take a lunch break. Mr. Schenk or Mr. Juliet, your next witness.
Lance Armor.
Mr. Harmer, if you please come on to the witness stand, and as you arrive, please remain standing and raise your right hand for the sir. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, you can be seated.
Warren, sir, can you say your first name and spell your last name for the record?
Lance Harmer, Harmer.
Where do you live?
Wolverine.
Okay, is Morgan Harmer your wife?
Yes,
Were you living there on May 6th, 2024?
yes.
Anything in out of the ordinary happened that day?
Yeah, my truck got stolen.
Okay. Did you give anybody permission to steal your truck?
No,
Okay, thank you.
Any cross-exam?
No.
Any questions from the jury for this witness? Okay, seeing none, Mr. Harmer, you can step down, and may he be excused from subpoena?
Yes, please.
All right, so what we're gonna do, folks, is take our lunch break. It's now just about noon. We'll start back up at 1 p.m. So if that gives you time based on your residence to go home, you can certainly do that. If not, you can grab lunch anywhere in town, and if you do so, please keep a receipt, not just your credit card slip, but the receipt of what you had. And if you give that to the bailiff upon your return, we'll see that you're reimbursed. This remind you not to have any contact with anybody involved in the case, and not to talk about the case with anybody, not even each other. And the bailiff will direct you as to how to leave and enter back. And the one of you that we did talk about, if you're unable to solve the issue we discussed, please let the bailiff know upon your return, and we'll address it with you. Okay. Are any questions about any of that process? All right, we'll
All rise.
please be seated. All right, anything that we need to place on the record from the people,
Not at this point.
from the defense? Okay, we'll be adjourned until 1 p.m.
The circumstantial evidence becomes as more witnesses take the stand. And here's the bigger picture. Cases like this show how powerful and dangerous circumstantial narratives can be. When there's no direct proof, the story matters. The logic matters. And the smallest inconsistency can tip the scale. Now I want to hear from you. Based on what we've seen so far, do you think the state is building a convincing case? Or is reasonable doubt already creeping in? If you found this breakdown insightful, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more in-depth, no-nonsense courtroom analysis. We'll be following every twist of this trial.